morning and welcome to our viewers here in the United States. Good afternoon to those in Europe and hello to everyone around the world. My name is Fran Burwell. I'm a distinguished fellow at the Atlantic Council's Europe Center here in Washington, D.C. I'm pleased to welcome you to today's event on national security and digital privacy. We have an important and timely discussion ahead of us. Timely because during the 20 years since the September 11th attacks, data and the ability for law enforcement to examine it and sometimes share it has become an intrinsic part of the fight against terrorism. But our discussion is also timely because that power should not be unchecked. And today it continues to meet challenges, even among friends in Europe. Our discussion is important because data privacy is important to everybody. From the emails we send each other to the tweets we write and the orders we place online, we assume some things will remain private and not be shared. Given this tension between national security and data privacy, the question is how to keep data flowing between Europe and the United States. With exports of digitally enabled services across the Atlantic, totaling $378 billion in 2019, this is not a small concern. Indeed, given the growing strength of the transatlantic digital economy, how we regulate the digital space is proving to be a core element of a strong US-EU partnership, and officials on both sides of the Atlantic increasingly recognize this. So it's no mistake that the US-EU Trade and Tech Council, announced during President Biden's trip to Brussels in June, was one of the first major announcements of renewed US-EU cooperation. Apart from the foreign policy issues that grab headlines today, the future of digital privacy, transatlantic data flows, and the question of how they intersect with law enforcement and national security will be crucial in defining the success of the transatlantic partnership. It's for that reason that the Atlantic Council, through both the Europe Center and the Digital Forensics Research Lab, have been working on these digital issues. The Council is founded on the premise that the United States and Europe are both stronger when we work together, and greater transatlantic cooperation has been our guiding mission at the Council. Building partnership in the digital arena will be essential for our future together. Today, we welcome Bruno Lassere, Vice President and Chief Justice of the French Conseil d'État, to the Council. Justice Lasserre has been key to defining France's digital regulations relating to data privacy and national security. Justice Lasserre, welcome. I look forward to this discussion. Before I turn it over to Ken Propp, a non-resident senior fellow with the Europe Center, please make sure to follow the event online on Zoom, and I hope you're all here, and follow the Europe Center for all things digital. Ken, over to you.
Thank you, Fran, and good morning to everyone. It's my pleasure to moderate this conversation with Chief Justice Bruno Lassere. I'd just like to remind people to please pose questions through the Q&A function. Before we move to the questions, we're going to have some opening remarks from Justice Lassere. Please.
Thank you very much. And a few words to say how grateful I am to the Atlantic Council for hosting the event, which in fact is very timely and very welcome. Very happy to be here in Washington, D.C., and I look forward to answering all your questions. Maybe a very brief note about why the Conseil d'État, the French Conseil d'État, is at the forefront of all these data issues. The explanation is in the peculiarity of the missions devoted to the Conseil d'État. Roughly speaking, we have three complementary missions which explain why sometimes we can anticipate and judge novel issues. First, we, as our name explains it, we are the independent legal advisor to the government and to the parliament when law is designed. We scrutinize draft bills, draft regulations, draft important regulations in order to check that these drafts are consistent with higher legal standards, are consistent with the rule of law. Second, we are a sort of public think tank, an independent one, who, in fact, by its own motion, or because we receive requests from the government, works and anticipates new legal issues dealing with public policies or public governments. And very early in the mid-90s, the Conseil d'État has invested much in understanding the internet age and the digital issues, working on platforms, working on the internet and fundamental rights. And presently, we are preparing new recommendations on social media or artificial intelligence. And third, of course, we are the Supreme Court for administrative cases. We receive 10,000 applications each year, but for 15%, and for the most sensitive cases, we are the first and last instance court which reviews government decisions or decisions made by national agencies on important issues. And it gives us a quick look on novel issues because we can make judgments on the substance, on the merits, in less than 1 year, for example. So that explains why we had been very lucky in having many opportunities to deal with these tensions, which have been summarized. Tensions coming from our fellow citizens. They want, in the same time, that data be protected. They want their personality be protected. And at the same time, they are tough in demanding the government to protect them against terrorist attacks or security risks. And of course, there are tensions in Europe. We must admit them. There are different views on these sensitive issues, differences between sometimes national member states. To be very frank, there are some worries in the eastern part of Europe which have known communism and mass surveillance. They are very, I would say, chilly about these data issues. And of course, there are sometimes the need for a dialogue between national courts and the European Court of Justice. None of them have the monopoly of interpretation of EU law, and the balance must be achieved through, I would say, a demanding, a rough and always renewed dialogue between judges. And that's what I will try to explain, taking examples of recent cases we had the chance to decide on. And both of them, of course, have consequences here in the US. I will talk about what I call the accidental American case, which deals with tax data. And the other one, which have been very much commented in Europe, is our recent case decided in April, the French data network case, which deals with the possibility or not of member states to impose telecom operators the obligation to retain connection data in order to fight against terrorism or to allow intelligence services to anticipate the risks.
Thank you, Judge Lasserre. Since you mentioned these recent cases, let's touch on them first. In the data retention case, your court interpreted a ruling from the European Court of Justice in the LQDN case and found a way to continue to allow the use of retained data for law enforcement purposes on the basis that there was a serious threat to national security that existed. In Belgium, there was a somewhat different approach taken by their Conseil d'État, simply invalidating the use of such data and handing the issue back to their legislature to rewrite the law. How do you reconcile the two different approaches, and could you explain to us how your court has sought to shape the French legislative debate on this? And then finally, do you see a concern that this determination that there is a serious threat to national security will be one that will continue indefinitely and pose risks to civil liberties?
Thank you for your questions. Well, first of all, I have to summarize, to explain, we didn't start from nothing in this dialogue between the ECJ and the Conseil d'État. And there has been a thorough examination of different referrals made by national courts, which led the ECJ, in fact, to lay the foundation of these rules governing the retention of connection data. And from 2014, the Digital Rights Ireland case to the 2020 Quadrature du Net case, these four cases, Digital Rights Ireland, then Tele2 Sverige in 2016, then Ministerio Fiscal in 2018, and at the end, the Quadrature du Net. All these questions have been referred by national courts. So we didn't start from nothing. There was a case law, there were rules, there was a position taken by the ECJ. And in fact, we at the Conseil d'État thought, of course, this state of law, this case law had to be respected. That was the starting point, but maybe it didn't take enough attention to the new threats, to the new risks our citizens face today. I mean terrorism, I mean the fact that today most of the crimes, and not only the serious crimes, are pursued and can be elucidated through connection data. It couldn't be anticipated in 2002 when the directive, e-privacy directive, was put into force. So what we made first was to invite, and that was a new initiative and something which is not so spread in Europe. We thought that the ECJ had to think again about the precedent cases it decided before. We invited by new questions the ECJ to refine, to fine-tune in a different way the balance it achieved through the different cases. That was what we did in 2018, formulating new questions to the ECJ, inviting the ECJ to take into account the new context of terrorism and threats to national security. We received the answer in October last year, to October 2020, and we had to draw consequences of this new ruling. To be very frank, the ruling was not welcome by intelligence services and security agencies, and the French government asked us very officially to rebel against the ruling, to put it aside and to rebuild a position independently of what had ruled the ECJ. That was not the position we took. We refused to say that the ECJ had violated its own competence, and we preferred to stay on the path of a dialogue, but a very demanding and I would say rough dialogue, trying to recreate the conditions for workable and maybe more pragmatic solutions under the umbrella of the European law, which had been just interpreted by the ECJ. The solution we took was the following. We considered that the existence of a threat. And of course, we took into account the terrorist context and the existence of threats to national security justified for the moment. It's not for the eternity, and it has to be reviewed each year, for example, under the control of independent judges. We consider that today the existence of threats, the national security context justified the right to impose general retention of connection data. Then we consider that we couldn't follow the ECJ, which had invited us to limit the retention of data depending on the persons or on the geographical zones, which could be maybe more pragmatic. We thought that it was not even possible or operational to pre-designate persons which data should be retained, or we couldn't identify more pragmatic zones where data could be retained instead of other zones. We considered that was not workable, that was not possible, and we preferred to put in place a system, what you call of expedited use of data. I mean, because we have the right to retain all the data, we should allow intelligence services and law enforcement agency to use that data, provided, and it's very important, they comply with the proportionality principle. It means that it will be under the control for intelligence service of independent authorities, which will scrutinize and give a prior authorization to the use of data, and for law enforcement activities, that there will be a proportionality constraint. Of course, to use this intrusive use of data, procurers will have to prove that it's necessary and proportionate to the seriousness of the crime. And taking into account these guarantees, we considered that the French legislation was consistent with European law, even if on 2 points we made injunctions to the government to adapt it to the European requirements. So that's an important, of course, ruling, which have been very much commented in Europe, which stays on the path of dialogue. And there is no monopoly of interpretation of EU law in Europe. It's a shared burden, it's a shared responsibility between the ECJ and the national courts. We didn't, I would say, provoke war between judges, which wouldn't have been a solution. We stayed on the path of dialogue, but of a demanding dialogue where all the parties play a role and stimulate the other ones in trying to achieve the best balance. Other national courts will have to draw the consequences of the same case. In Belgium, the answer has been slightly different, and the Constitutional Court of Belgium asked the government to re-prepare a new draft bill, which will have to be voted by the Belgian Parliament. We chose a different path, but we have to be understood. As the Supreme National Court, we have to combine two standards. The first one, and democratically is very important, is our constitution, which is at the top of our legal standards, and of course is a democratic constraint, and of course the primacy of European law. And in that combination, we have really to take into account patiently and laboriously in some way to combine both in order to achieve the best balance. That's what we try to do, and I will be, of course, very happy to develop in more details what we decided on this very sensitive case.
Thank you for that very thorough answer, which gives us real insight into the dynamic that goes on between the government of the court and also other courts. We've had a question about commercial privacy that's come in that I'd like to pose to you, and it has to do with what's called the right to be forgotten or the right to erasure under European law. In 2019, the Court of Justice decided a case that I believe came from France, from the CNIL in the first place, about whether a search engine would be required to de-index or remove search results that appear on domains outside the European Union. So it was a case about the extraterritorial effect of EU law, and the Court of Justice found that the GDPR provision did not actually require extraterritorial de-indexing, but it left the door open for member state data protection authorities to go beyond that. My question to you is that a sufficient resolution of this issue? How has it developed more recently in France, and do you see the need here for further guidance on the matter from your court or others?
Thank you very much. On this right to be forgotten, right to differencing, first of all, I think it's very important to insist on the importance of the cases decided by the French Conseil d'État, not only on this geographical scope of this right, is it limited to European residents and in which context, but maybe because this right has been invented by the ECJ, it's sort of a right which is not written in texts, in directives or regulation. It's a right which has been created by judges. That was very important to provide practical guidance to citizens, to social media, to search engines, and of course, to CNIL, our National Data Protection Agency, because we needed really to define in a very practical way how this right could be used by citizens. I mean, the right to be forgotten for European residents is their right to request the information about them, which can be searched through a search engine, be delisted and made inaccessible in a certain number of cases. And the Conseil d'État made a very important decision in 2019. We had 13 cases in very different situations where we tried to provide, I would say, a sort of manual for and very practical manual for search engines and our National Data Regulatory Authority, distinguishing according to the sensitivity of the personal data involved, and then specifying how the balance must be achieved between the applicant's right to privacy and the public's right to information, how this balance must be carried out. On the geographical scope of this right to be forgotten, we followed the case made by the ECJ in the Google Spain case, and we quashed the decision made by the CNIL, who had given to the sanction imposed on Google a very large territorial implication. We thought that the CNIL had not the right to impose this right outside Europe, that we couldn't give an extraterritorial consequence to this right to be forgotten. So our decision, I think, is very consistent with the decision made by the ECJ. We have not the pretension to find ourselves the solution, but we mean that's a right which has been given to European residents. And of course, we consider that there is maybe a need to create or to organize his right at a more global level, but it would be achieved through international dialogue. And we are confident that this dialogue will prove to be effective. We as judges have to decide on cases, but not to redesign the law we apply when it proves unsatisfactory or needs to be refined or precised.
Thank you. We've had a follow-up question on data retention in the national security context. It comes to us from the European side of the ocean, from Professor Theodore Christakis of the University of Grenoble, who asks whether a case that's currently pending before the European Court of Justice, the Graham Dwyer case, might be an opportunity for the ECJ to adapt its ruling in the same more flexible direction that the Conseil d'État in France has taken. Is this an opportunity for further rough dialogue, as you call it, between the courts?
Oh, sure, I do agree. I mean, when there is a dialogue, it means that every party listens to the others and takes into account in our own decisions all the insights given by the other participants to that dialogue. A dialogue is not something between, I would say, the teacher and the pupils, but it's a sort of interactive dialogue where everybody is at the same level, and collegially, collectively, we have to achieve a better balance. A better balance between contradictory injunctions coming from our citizens, a better balance between European law, which deals with fundamental rights, but has not competence on national security, on law enforcement issues, and a better balance between democratic standards, which are, of course, of primary importance in each member state. I mean, the Constitution, and of course, the need to harmonize the law to create an integrated market and a place where fundamental rights are guaranteed. So I welcome, of course, this opportunity to continue our dialogue, and that will be really the mind with which we envisage the following steps. The fact that the ECJ is fed in its case law by referrals made by national courts is essential, because they can't interpret law abstractly. They have to answer precise questions, and questions which derive from cases where we have very, I would say, practical, very operational needs to answer. And this dialogue is interesting by that, because we are not teachers, we are not professors, we are not interpreters in a very abstract way. We have to work out solutions. We have to provide solutions to make things work. And that's our responsibility. And I consider that's a pride, not only to interpret law, but to work out solutions. That's why our fellow citizens demand from us.
Thank you. One of the recent changes in the European dialogue has been the departure of the United Kingdom from the EU. And the UK, of course, was a very strong voice previously in these discussions on the balance between national security and privacy. How do you see that departure affecting the ongoing discussions in Europe? Will the UK continue to be an important reference point, or has it gone off in its own direction and you will essentially be having a continental European debate now?
As a European, you know, I regret, of course, his Brexit. We are sad about that move. We have, of course, to respect that because it has been decided by the British people. But as a really European committed to build a common future for our continent, I regret that decision. We have to do without the United Kingdom, and there are different paths, different ways to continue our dialogue with them. In December, for example, we'll have bilateral exchanges with the UK Supreme Court in London, and I'm very keen on maintaining this dialogue at the judicial level, not, of course, in the European arena, but through, I would say, this continuing bilateral exchange and dialogue. And to be very frank, I'm sure our British colleagues will bring a lot in our own reflection on that issue, but on many others.
Thank you. Well, it's good to hear that these dialogues will continue despite the formal change in the UK status. I wanted now to put a question to you from our audience that relates directly to the US-EU relationship, and in particular to the efforts to resolve these questions of government access that brought down the Privacy Shield framework, for example. There is now an effort to have a broader multilateral discussion on these issues and to set rules for government access. That has been underway at the OECD in Paris. The Council of Europe in Strasbourg is also pursuing this subject. How do you see this moving forward? Will the multilateral discussions potentially be an important role in satisfying European courts about government access rules in the United States?
Well, I think, of course, the multilateral approach is the most fruitful way to progress. As you mentioned it, there are different fora which can be used to progress. You mentioned OECD, you mentioned Council of Europe, and of course, OECD must be credited for, having, and that was not so easy to get. That was a hope, that was a dream at the beginning, and which is becoming progressively a reality. Tax harmonization was not an easy issue to tackle, and thanks to the huge involvement of the OECD, and of course the will shared by member states to get an agreement, there has been huge progress on that aspect. For data protection and the question of government access to data, to protect the free flow of data, which is a condition to build an open and really effective global market. I think these, of course, fora should be mobilized, but how to say that? Everything will be eventually under the control of judges. I take the example of a case we decided on, and I've not already mentioned. It is the case on what we call accidental Americans. I'm very sorry to use this word, accidental Americans, but it talks about Americans who get the US nationality because they were born on the US soil, but have stopped to be parts of the US community because they moved abroad, and so for some of them chose France as the land where they want to live in. We had a case which came from an US administration requested the French banks to transfer the data about personal accounts detained by these accidental Americans to the US in order to check that they couldn't be taxed in the US. And the question was, that was a very interesting question, is the Foreign Account Tax Compliance Act, the US FATCA Act, consistent with the European GDPR, and is the bilateral tax agreement between the US and France which of course allows the FATCA to be applied in France consistent with the GDPR. We made a very interesting decision, and it was decided in July 2019, where very carefully we tried to balance and to understand the stakes of this case and the needs which were expressed. In the same time, there was a legitimate purpose of improving compliance with tax obligations, especially from the US side. And for that, it provides for the selection, collection, and processing of data in a manner, and that was the care we took in forging that balance, in a care that is adequate and proportionate to that purpose. And this case is interesting because the Conseil d'État, as a judge of a national judge, tried to assess itself if these guarantees of adequacy and proportionality were met in the US. So very carefully, we tried to study the US legal framework. Are the principles of transparency and confidentiality of tax data respected? We said roughly yes. Are there civil and criminal remedies before the US court to make that guarantees effective in the event of non-compliance with these obligations? We answered yes. And in fact, that's very interesting because instead of taking a sort of abstract adequacy decision, we as a judge invested directly in understanding your legislation to be sure that information could be shared without breaching our fundamental rights of privacy. So in that respect, there is, of course, a place for, I would say, politicians, for diplomats to forge international rules, but there is a place for national judges to fill the holes, to fill the gap, in fact, and to very practically to refine and build workable balances, workable solutions. And that's what we did in that interesting case.
Thank you. That case is less known in the United States, and I think it's an excellent example of the kinds of inquiries that will be going on in the future with foreign courts looking at US law and vice versa. We have time for just one more question, and it also relates to the question of commercial data transfers. And that has to do with the ability of foreign cloud service providers, many of whom are from the United States, to continue to offer their services in European jurisdictions. We've seen the advance of data localization requirements, data sovereignty requirements. This has entered into the debate in France through your national cloud strategy, through rulings from the CNIL, and most recently from statements from your cybersecurity agency. You have reached an important decision in this area in the last year in the Health Data Hub cases. Do you feel that the types of safeguards that your court suggested in that case is a firm basis to allow these types of services to go forward?
Thank you very much, and congratulations for your knowledge about our case law. Fantastic. Thank you very much. Well, we made a decision you mentioned very recently. It was in October last year. And to be very frank, it's not a decision on the merits. It's what we call an emergency decision, a sort of provisional decision. I must mention that the Conseil d'État has been incredibly busy during the pandemic, and it's not the end of the story, of course, because many aspects of the management of the crisis by the government and local authorities have been contested to the administrative judge, and especially to the Conseil d'État, who had to decide finally, eventually. We received more than 900 applications in 2020, and among the contests we received, among the application we received, there was litigation dealing with the health data hub issue. The government created a public platform, as the name is Health Data Hub, in order to facilitate the sharing of health data, to support research and to know more about the COVID-19 virus. So there was obviously a general interest to collect and exploit these data in order to fight more efficiently against the pandemic. But on the other side of the coin, there were worries from citizens or from NGOs telling us, well, there are risks that this data could be transferred to US authorities because the public platform had signed an agreement with the Irish subsidiary of Microsoft in order to host the data and to allow the use of software which was necessary for this data processing. The decision made by the Conseil d'État, which is an emergency decision and not a full decision on the merits, is very pragmatic. We said we have to compare the different sides of the coin. And there is a general interest to collect immediately and as soon as possible this data. There is a need to process them in order to know more about the pandemic and to fight efficiently against it. And if there are risks, and we have not underscored these risks, we don't see immediately a risk of use by the US authorities or a possibility to transfer this data to the US authorities, which could undermine our fundamental rights. So what has been decided is that there was no urgent reason to suspend, to freeze the hub, but we insisted in the provisional judgment that we'll be very vigilant about the practical guarantees which would be put in place in order to be sure that principles of adequacy, of proportionality would be respected.
Thank you, Judge Lassere. We've sadly reached the end of our time, and I'd like to thank you for the insights that you've offered into how the French judiciary interacts with its government, with the European Court. This is a very important and fast evolving area of digital law and policy, and we are grateful for the opportunity. I'd also like to thank our viewers who have been with us for the last hour, and to remind everyone that you can follow the activities of the Europe Center, its events and publications through our website and online. Thank you, everyone, and goodbye.